thank you very much indeed for joining this part 2 of the thrilling instalment of public law updates that Jane and I are going to present. We may be joined by Mark Calway later on, but he's got tied up in court this afternoon. I hope you found the first session that we had useful. You'll remember that the handout that we've prepared is based on 3 columns. That the first column gives the name of the case. The middle column is the one that you go to when, if you're like me, you're rushing into court and thinking, oh, there's a case on that, where is it? If you look down the middle column, that should enable you then to find the case that you are rummaging for. And then on the right-hand side, we've tried to cut out any of the padding and give you the hard-hitting bottom line of what you need to know from individual cases. We hope you find it that helpful, and it means we hope that you won't have to wade through a lot of stuff on the internet or in textbooks to find the answer to your case. Okay, so we're going to start with Jane is going to take us through some cases on risk assessment and what's been said about that recently by the Court of Appeal. So, Jane, over to you. Thank you.
Thank you, Stephen. Okay, so we're looking at case number 26 on your handouts, which is the case of LG. And I'm just going to give you a little bit more of the background. As Stephen says, the summary there is to give you the key points. So I'm just going to give you a little bit more of a flavour of the case. So this one was an appeal by the mother regarding a court's decision to remove her 2 children. She had O, who was a little girl aged 5, and Y, who was a little boy aged 1. O and Y had different fathers, and O had been spending regular time with her father, but there were concerns about Y's father, who we will call Mr. F. Mr. F had 4 older children from a previous relationship, and they had been the subject of care proceedings themselves. And a fact-finding hearing was heard, and in fact by the same judge who had made findings against Mr. F in relation to his older children. And the findings included that he had assaulted and threatened 3 of his older children, in fact with a weapon, and that the mother had failed to prevent that. The judge in that fact finding had described Mr. F as a violent and cruel man who would likely cause harm to any child in his care. So following Y's birth, the local authority issued care proceedings and sought a supervision order to protect the children from Mr. F. In addition to the interim supervision order, mother gave an undertaking that Y's contact with Mr. F would be limited and supervised. However, a month before the final hearing, mother said that she'd separated from Mr. F and she was willing to agree to protective measures for the children. And having complied with her undertakings that she'd given earlier in the proceedings, she sought an adjournment to further test her compliance. The judge refused the application to adjourn and determined that the risks from Mr. F were too great for the children to remain in mother's care. And the judge ordered that O should go and live with her father and Y should live with his maternal grandfather under a special guardianship order. The local authority had recommended mum's contact with the children should be supervised by the maternal grandfather or another approved family member, but no supervision order was made, and the order just contained a recital that the mother's contact should just be supervised. Mother sought a stay and permission to appeal. The application for a stay was refused, and there were 3 grounds of appeal. The first was a failure to make a proper risk assessment. The second was a failure to make key findings of fact, which fed into ground 1. And the third was a procedural error in relying on incorrect information. And this actually wasn't pursued. It related to seating arrangements outside of the court, and it was not something that had been raised within the hearing. So it effectively fell by the wayside. And you can see there from the summary, ground 1 in detail. And Lord Justice Jackson, noted that the judge had thought carefully about her decision and referred to the relevant case law, REF, and proposed that in assessing a risk of future harm, the court should ask itself a series of questions which need to be tailored to the individual facts of each case. And those questions are outlined there. What is the type of harm that may arise? What is the likelihood of it arising? What would be the severity of the consequences for the child if it arose? And can the chances of harm happening be reduced or the consequences mitigated? And Lord Justice Jackson went on to say that further questions needed to be asked by the judge, which were, what are the settings and circumstances in which Mr. F would have a realistic opportunity of harming the children? What was the likelihood of those settings and circumstances arising and remaining undetected? And if the mother is incapable of being instinctively protective, can the likelihood or consequences of harm be reduced by protective measures such as obligations imposed on the mother, the vigilance of O's father, the vigilance of the maternal grandfather, and the statutory powers of the local authority acting under a supervision order? And both the mother and the local authority had provided a list of protective measures that they considered could be put in place, but they had not been addressed by the judge in her judgment. And so Lord Justice Jackson stated that the judge had made no clear findings about whether the mother had complied with her obligations over the previous year. And as a result, the appeal was allowed and the application was remitted for a rehearing by a judge to be nominated by the family presiding judge. That's that case. And then I'll move on to number 27, which is Re-T. And this case concerned an appeal by both parents regarding their 3 children. It was 3 little boys, A1, who was aged 11, A2, who was aged 9, and A3, who was 16 months. At the final hearing, care orders were made for all 3 children and a placement order for the youngest child, A3. Just to give you a little bit of background on this one, A2 had suffered a head injury back in 2015 when he was around 15 weeks old. And he was found to have a linear skull fracture with overlying hematoma. And as a result, the local authority issued care proceedings for both A1 and A2, as well as the older half-sibling D. The court had a finding of fact and found that the head injury to A2 had been caused by the mother. And after that, the parents separated. A1 and A2 were placed in their father's care under a supervision order, which expired in 2017. In 2019, A1 and A2 were taken to Africa by their father, where they went to live with the maternal grandmother for around 4 years. The father, having taken the children to Africa, returned to the UK just a month or so after taking them. A3 was then born in March 2023, and it turned out that the parents had concealed their continuing relationship. However, A3 had actually remained in his mother's care since birth because the mother had moved to a different local authority area and had not told professionals about the previous proceedings concerning A1 and A2. In September 2023, the father actually brought A1 and A2 back to England, and he then placed them in the care of their mother. And so for around 5 weeks, all 3 children, A1, A2 and A3, were in the mother's care. In or around October, a health visitor became aware of the history and alerted the local authority to the fact that she'd got the 3 children in her care. And unsurprisingly, the local authority issued proceedings, and that was despite the children being found to be well presented and the home was clean and tidy. And all 3 children were then placed in foster care. At the conclusion of the care proceedings on the 19th of August 2024, Her Honour Judge Tyler made final orders. And as I said, that was care orders for all 3 and a placement order for A3, the youngest. The parents applied for permission to appeal, and that was granted on the 27th of November 2024. And it was argued that there were a number of problems with the judge's reasoning. The Court of Appeal set aside the care and placement orders and remitted the case for a rehearing. And in the lead judgment, Lord Justice Peter Jackson decided that the trial judge had not properly undertaken the level of analysis that was required. And you'll see from the summary there, I'm not going to read it all out to you, that he set out a clear list of questions that must be addressed in a judgment. And he concluded that the original judgment then did not address the crucial questions. And you'll see paragraphs 34 and 35 outlined there. So that's the 2 cases that we've got for you in relation to risk assessment, unless Stephen's got any more to add to that.
Thanks, Jane. Those 2 cases I think are really important, and I've had to write judgments where the style with which you approach issues of risk assessment, I think has changed because of the case that's referred to in the handout, the case of re-F for child placement orders proportionality. And that's the founding father of the 2 cases that Jane has referred to. And it suggests that there should be a really structured approach within a judgment to risk analysis. And I don't think you ever used to get that. I think that there was a sort of general approach of the judge analysing the evidence and saying whether he or she agreed with what had been said by the social worker and the guardian. Job done. And I just don't think that's enough these days. I think you, the judge, is expected to demonstrate judgment on the issue of risk and to break down the analysis of risk into the headings that are stipulated in these cases. And if a judge doesn't, then you can see what happens. There is an appeal. And last week, there was another case in the same trend that I've just summarised for family law. The reference for you is H, Care Proceedings Risk Assessment, 2025, EWCA Civ 727, 2025 EWCA Civ 727. And this case, I think, is a reminder of just how important it is really to watch what is said in a judgment and analyse whether it is sufficient. I used to sit in the Crown Court quite a bit for about 7 years, along with sitting in other courts. And in the Crown Court, where a judge gives a summing up, there are certain things that he or she must say to the jury. And if he or she doesn't, then that can found the basis of an appeal. And what happened in this case of H that I summarised last week is this, that the judge rejected the local authority's application for a care order, notwithstanding the support for that by the guardian. and gave a summary of the background, referred to the threshold criteria, but then went on to say this: I don't propose to summarize the evidence that I've read and heard in this case. I have kept it all in mind when reaching my decision. Now, in the days when I was at the bar, if you went to the Court of Appeal and tried to challenge that, you would have had one of the Lord Justices, because they were all Lord Justices in those days, saying, you're not going to get anywhere. The judge had it all in mind, as he said. But this appeal was allowed, and Lord Justice Baker, giving the main judgment, said that the approach, or the way the judge approached his judgment was just not enough. Lord Justice Baker said it's axiomatic that a judge must consider the totality of the evidence. And it's not just that the judge must consider it, but the judge has got to demonstrate that he or she has done so. The other thing that happened in this case that the Court of Appeal commented upon is that the judge referred to the threshold issues and left the analysis of fact there. Now, as we all know, threshold is determined as at the time that the protective measures are taken by a local authority. That may be right at the start of the proceedings, or indeed in some cases where there's been accommodation or intervention earlier. What the judge has to do at the stage of deciding whether to make a care or placement order is to conduct a contemporaneous evaluation of the totality of the evidence. If you don't do that, then of course, as soon as the threshold criteria are satisfied, in many cases, that's the end of it. And you ignore all the assessments that have been done during the currency of the proceedings. You ignore any efforts that the parents have made, drug rehabilitation, parenting courses and the lot, because they all become irrelevant. You don't analyze the evidence. You just say, I've kept it all in mind, and you compartmentalize the evidence and ring-fence the threshold criteria. So that's an example of a case. I think the lesson from it, however, is really watch what your judges say in their judgments. And if you do get a judge who says, well, I've taken it all into account, I don't need to recite it, just think, is that enough? And if it isn't, have a look at this case, 2025, EWCA Civ 727, and I'm sure you'd want to instruct Jane on the appeal. There you are, Jane. That's a plug.
Thanks for that plug, Stephen.
No, I'm always there. I'm all heart, Jane, as you know. Well, we're going to go on now to look at some other issues that arise. And we're looking at case number 28 on the handout. And I hope everyone's been able to get the handout now. This is a really sad case, I think. It involves a young man who I think was 17 by the time all this came to court. When he was young, his parents split up. He lived with his mother and his stepfather. His mother died when he was, I think, 14, and he was really badly affected by her death. He then fell out with the stepfather. And as any parent of teenage children will know, teenage years are difficult for the teenagers and for those who are trying to look after them. And there were teenage problems. So TW left his home where the stepfather was living, and the only place for him was to go to live with his father, who had split up from the mother when he was very young, and his own and TW's older brother. TW's father and TW's brother were not able to give him a bedroom in their homes. And so as a teenager, he was sofa surfing between his father and his brother. He was provided with some accommodation for a short while, but that broke down as well. And the issue became whether he was a child in need, because he was still under 18, for the purposes of Section 17 and Part 3 of the Children Act 1989. And if so, whether the local authority had acted in a way that was Wednesbury unreasonable in refusing to provide services for him. The judgment of Lord Justice Jonathan Baker analyses the meaning of the phrase child in need. And so can I recommend, if you do have to consider what those words mean in Section 17 and Part 3, then look at this case, because there's an extensive definition of it that we've tried to summarize in the handout. The conclusion that the Court of Appeal reached was that the judge had been right to reject the application for judicial review. The Court of Appeal said that it would have been open to the local authority to conclude that TW was a child in need, but the evidence got nowhere near demonstrating that the decision of the local authority not to do so was so unreasonable that the judicial review test was satisfied. And the judicial review test is, was this a decision that no reasonable local authority could reach? Was it irrational? And that very high bar wasn't met. Now, the moral of this, I think, for anyone advising teenage kids and wanting to put pressure on local authorities to provide Part 3 support for their kids, is you've got to get your ammunition lined up. You've got to get your ducks in a row. Otherwise, you're just going to get batted back by the local authority with all the pressures that they have on their funds. And so you have to be able to demonstrate that your client is a child in need within the definition that's given in this case, and persuade the local authority that they should exercise their statutory abilities to provide services for your client. It's not an area to enter into lightly and without preparation, because otherwise the same will happen as happened to TW. So I think that's the message from that case. Now, the next case is, I think, really interesting. It'll be interesting to see how these issues develop. This is a case, case number 29, Re J, that came before the President. It concerned a 16-and-a-half-year-old who had obtained testosterone from an internet organization called Gender GP. The parents were concerned and wanted that to be stopped. And so that is how the case came before the President. The parents wanted the President to give wide guidance about the prescription of HRT and puberty treatment and puberty blockers for young people under the age of 18. On the facts of the case, the president declined to do that, because what happened was that another agency called Gender Plus was identified that could provide appropriate assessment of the young man concerned over a period of 6 months, with the case then returning, if necessary, to the court once that assessment had been completed. As it happened, Jay's testosterone levels were sufficiently high so that he did not need the prescription over that period. I think there's going to be more of this. I think that we're going to see more applications of this nature in this really difficult arena. And can I draw to your attention that Mr. Justice MacDonald has just given directions where, in a case that was reported for the instruction of an endocrinologist, he rejected applications for a psychiatrist to be instructed in a case concerning 17-year-old and the provision of HRT, hormone replacement therapy. And the case reference for that is ATN versus BTN 2025 EWHC 1325 for the Family Division, a decision of Mr. Justice MacDonald, 2025 EWHC 1325 Family. And so if you're interested in this area, watch what happens there, because I think that is a case that's going to develop. Now, the next case, case 30, we've all had cases where somebody starts writing into the court, bombarding the solicitors with correspondence. In days gone by, before emails, it would be the manuscript documents that continued round the edge of the page, and you would get them in volumes coming in. And people like that not only cause distress amongst professionals that they don't really understand, but they also clog up the system hugely. In this case, the person concerned had contacted HMCTS on 760 occasions in a tone that was highly abusive and threatening. I think we've all had cases exactly like that. And so this case is an example of what you can do when that happens. Please do think about applying for a civil restraint order if the rules, the family procedure rules relating to that, justify that application. Please also think about whether the expanded powers under section 9114, now 9114A, can be used as well. And the third thing I want to mention is there is jurisdiction in the High Court for injunctions to be issued to prevent someone engaging in this type of activity. So if this starts developing in a case, please raise it with the court. As a DFJ, these used to be referred to me, and then I would raise them to the family presider, the family division liaison judge. But don't allow yourselves to be trolled. I've been trolled, and it is wretched when it happens, really distressing. So the other thing that I used to do where this happened is call the person into court straight away. I would robe and I would see them in court. And if you nip this sort of issue in the bud, usually it goes away. And I never had to get to the point of contempt in this regard. I have in others. So if you get this problem, have a look at Barnsley Metropolitan Borough Council. If anyone's from Barnsley, you'll know all about this, I'm sure. Case number 31, I'm going to take quite swiftly. This is Mrs. Justice Leven, who gave leave for a child in care to be taken on holiday to Spain. I don't know what happened, but the application was opposed by the local authority and by the Guardian, so it was a very brave decision, if I may say. But the child was living at home under a care order, and the parents of the child wanted to take the child to Spain. And in this international world in which we live, Mrs. Justice Leven said, you can do it. So if you're acting for a parent and you want an example of parents being allowed to take the kids to Benidorm, and we've all watched Benidorm on the telly, I'm sure, and can have the theme tune ringing through our heads while I speak. Hopefully, I can. If you get that, then here we go. That's the case you might want to have a look at. And what Mrs. Justice Leven said was part of it was more likely that risky family members might meet up with the parents and the child whilst on holiday in the United Kingdom than whilst in Spain. And that is where a viewing of a few episodes of Benidorm might really help. I'll move on rather quickly from that, I think. Case number 32 is about non-therapeutic circumcision for religious or cultural grounds. Now, I've heard quite a few female genital mutilation orders, and I'm not trying to compare this with that because there's a statutory scheme in relation to it, but it's quite interesting. There's only limited case law concerning it. The case that you need, if you get one of these, is the case that's referred to in the notes of Re P circumcision child in care, but that the reference is in the notes. But in this case, it is an example of the application of the principles in Re P. Mr. Justice Cobb considered the case, and what he said is it's a straight welfare determination. Apply Section 1 of the Children Act and the welfare checklist, and that's what he did. And accordingly, he refused the application for non-therapeutic circumcision on the facts of the case. I think it's important to ensure that if you do get a case of that nature, you do focus on the welfare checklist, and your arguments are structured around Section 1, particularly 1.3 of the Act. And in that way, if as lawyers you structure your arguments around the statutory circumstances, you're going to look professional. And I think that's what you want to do. So could I urge that on you, please? If you get a case where the welfare checklist arises like this, go through the welfare checklist with the judge. This is why we say this is the right thing to do, and this is the conclusion that you should reach. The next case, Re E. We would have thought that the Children Act 1989, which came into force, I think, on the 14th of October 1991, a long time ago, would have been pretty much trawled through, and every possibility for litigation would have been exhausted. But no, this is Section 37 of the Children Act. And His Honour Judge Martin Davis, who I know and I get on extremely well with, I hope, he had this issue at first instance. So the question is, does the power under Section 37 of the Children Act 1989 only apply to the children who are the subject of the relevant proceedings, or does it apply to any child the judge hears about and thinks might benefit from a Section 37 analysis? And the answer is that it applies to subject children, although you'll see the slightly more expanded analysis that we've included at the end of the note, that Lord Justice Baker, where I say, however, Lord Justice Baker LJ also stated, and what he's saying there is that we weren't addressed on any other enactments. And one example may be proceedings for a non-molestation order under Section 42 of the Family Law Act, and whether that can apply more extensively to children who are referred to within those proceedings, but aren't in fact the subject of the applications. So that's something for someone to take to the Court of Appeal. And then, Jane, there's your second brief that I'm going to...
Well, actually, Stephen, I dealt with a case the other day, but it was one that I'd come to quite late. And actually, the court had done exactly that, ordered a Section 37 investigation in relation to a non-subject child.
Oops. Okay, well, there you go.
So, yeah, I'm glad I was not involved at that point.
On you go. We're going to turn to adoption. And I mentioned to you the case I summarised last week about the judge who said, I'm not going to summarise the evidence that I've heard, I've got it all in mind. I'm afraid this case of Re-C, case 34, is the same judge in that. And in that case, in this case, Re-C, the judge refused to make a placement order because of issues relating to sibling contact. The child concerned was going to have contact with siblings, and the judge therefore concluded that the correct solution for the child was not adoption. So off they went to the Court of Appeal successfully. The message from this case is that where you have issues of sibling contact arising from a case where there's an application for a placement order, you can't simply say, well, there's sibling contact, that is not compatible with the making of a placement order, and therefore I'm going to refuse the placement application. And that is actually something you see, I think, argued quite a bit. Jane, I don't know if you've seen that happening. It's a difficult dynamic to deal with.
It's becoming, it's being asked for a lot more, but I don't see much of a sea shift with certain local authorities, and I won't mention any names. I think some are more willing to consider it than others. And I had a case actually earlier this week where I was making an application under Section 26 and the judge refused it, but on the basis that the local authority had indicated it would complete a risk assessment and review the issue of direct contact once an adoptive placement had been identified.
Yeah, and that's exactly the point that they say that they don't approve of, do they not, in this case. What you can't do is kick the can down the road to be dealt with at a later stage, because here, as they say, as we put in the note, considering and ruling upon post-adoption contact at the placement application stage was the correct and proper use of Section 26. The template for post-adoption contact is therefore set before any matching is undertaken, and the potential for this issue to be kept flexible for exploration with potential adopters is avoided. Ultimately, adopters may choose not to be bound by such orders, or contact may cease due to other matters that are not foreseeable at the time of the placement order, but the concern that contact may become the subject of agreement between local authorities and prospective adopters should reduce as a result of this case. So this is the Court of Appeal saying, we mean business with this. This is a case that you need to be aware of, and kicking the can down the road is not the way to do it. You address this at the placement stage. So I hope that is one that people will watch. The next case of Re-A and B concerns Section 83 of the Adoption Act, it is in fact illegal to bring children from abroad into the country for the purposes of adoption. Okay. Now, in this case, the applicant went to Pakistan and got legal advice there. The legal advice was that an adoption order wasn't available, but a guardianship order was, and a guardianship order was made in Pakistan in her favour. She brought the child to this country and then realised that the guardianship order that she'd obtained in Pakistan was not sufficient to legitimise the child in the way that she wanted within her own family. So she applied for an adoption order. Did that fall foul of Section 83? The answer to that was no, because when she came into the country with the child, she actually thought that she had done everything that was necessary to embed the child within her family. So at the time of entry, she was not acting in a way that offended Section 83. Section 83, and I've had to look at this quite a lot, does need very careful reading. And if you get a case of this sort, do please make sure that you study it carefully when giving advice to people in this position. If they've got it wrong, it can be a criminal offence, and it can be devastating for them. The really difficult cases are when people travel abroad to, the cases I've had have usually been from to countries in Africa, and for enormously good reasons, that they find an orphan and want to give that orphan a better life. People who are usually well motivated. There are some, of course, who are not. And people who do go abroad to get children and bring them back to this country for all sorts of other reasons. And that's why Section 83 is here. So it's serious business, Section 83. And if you get a case where this might arise, look at it very carefully. There are specialists who deal with this area of law. And I can tell you, when I've been sitting and I've had this issue, I've really benefited from having somebody who really knows the score on that issue. But be careful is the message from that case. The next case, case 36, is re X and Y, children adoption setting aside. Adoption is entirely different to other forms of orders concerning children. It changes children's status and it legitimizes them within the adoptive family. And the issue in this case was that there'd been an adoption order and things went pear-shaped within the adoptive family, and there was an application to revoke the adoption order. The adoption order itself, everyone accepted, had been validly made at the time. Could it be revoked? The case came in front of Mrs. Justice Leven, and she suggested that there is a very narrow jurisdiction to revoke an adoption order. But on the facts of the case, she concluded that the case that we're looking at, X and Y, did not fall within that very narrow jurisdiction. Off it went to the Court of Appeal, and they said, far from it being a narrow jurisdiction, it's a jurisdiction that doesn't exist at all. For the reasons that we've given, the appeal must be dismissed, rather than holding, as all parties submitted was the case, that Leven J's interpretation of the extent of any inherent jurisdiction to revoke an adoption order was too narrow. We have concluded that the reality is that no such jurisdiction exists. So that's the end of that one. A and Adopt London North, case number 37, does a local authority have a funding obligation to adopters in a non-agency adoption? So, typical example would be a step-parent adoption, a non-agency adoption. And the swift answer is no. Of course, the local authority, or the local authority rather than adoption agency in these circumstances, has a discretion to provide services if the circumstances of the child fall within the necessary statutory provisions. But a local authority is not under an obligation to do so. So Mrs. Justice Tice said the local authority may offer such services and has a discretion to do so. Section 4, subsection 5 of the Adoption and Children Act requires the local authority, if it is to offer adoption support, to prepare an adoption support plan and keep the plan under review, but it isn't under an obligation to do so. Case 38 is, I think we're going to end ahead of time, so we can all get the barbecues lit up, hopefully. So case number 38 is a decision of Mrs. Justice Judd. Now, section 42(7)(b) of the Adoption and Children Act says that an adoption order may not be made unless the court is satisfied that sufficient opportunities to see the child with the applicant have been given where to the local authority within whose area the home is, and that relates to a non-agency adoption. So the local authority have got to have an opportunity to see the child living with the applicants before an adoption order is made, is what it means. And in this case, that hadn't happened. And all the parties said to Mrs. Justice Judd, well, never mind about that. Just you can get over that one, and we can just work our way around it. Please just go ahead on the facts of this. Everyone supports the making of the adoption order. Just do it. And she said, no, I'm not going to do it. I'm not going to read down section 42, subsection 7B of the Adoption and Children Act 2002. You're going to have an assessment. I mean, on the facts of that case, it was no great burden to anyone. It just meant they all went off and had an assessment. I'm pretty sure, since everybody supported the adoption, back the case came and everyone said, yes, carry on with it. But what you can't do is dodge that statutory provision. There are workings around other provisions, and we're just going to look at one more before the barbecue summons us too much, because there is a case that I need to refer you to that was we've summarized for family law. I think in the next volume it'll come out. Can I mention to you, as the last case, the case of J and K, London Borough of Haringey, 2025, EWHC 1268 family. That was a case of a 17-year-old. So the 17-year-old was the subject of the application. The applicant for the adoption order was a man who had been in a relationship with the 17-year-old child's mother, but they'd separated. Unusually, the man, who was not the child's father, lived close by. He and the mother co-parented the 17-year-old for years. The man, the applicant, spent lots of time not only with the 17-year-old, but also with the mother. They spent weekends together as a family. And the 17-year-old had a bedroom at the applicant man's house, although as a 17-year-old, he didn't stay there at the time. The problem for the judge was that Section 42.3 of the Adoption and Children Act 2002 provides that an application for an adoption order cannot be made by a partner of a child unless the child has had his home with the applicant for 6 months preceding the application. So was this man a partner of the mother, and had the child lived with him in the way that was necessary for the purposes of that act? The mother and the man were not in a romantic relationship, but they operated together as if they were parenting a 17-year-old and had a commitment together to do so. The judge concluded that, having looked at another case that's referred to in the judgment, that the man, the applicant, could be treated as a partner of the mother in the sense that was intended within the act, and also that a child may have more than one home, and here the child had a main home with the mother, but also treated the home of the applicant as if it were a home as well. And on that basis, the judge made the adoption order and said Section 42.3 of the Act was satisfied. So it's not reading down the statutory provisions, as he was asked to do in the case of Re B and refused to do, and said there must be an assessment. This was applying Section 42.3 in a purposive way, and concluding that the adoption order could continue. Right. So,
Stephen, can you just repeat the citation of that last case, please? Someone's
of course.
in the chat.
Okay, so it's J and K and London Borough of Haringey, and the reference is 2025 EWHC 1268 for the family division. 2025 EWHC 1268, so 1268.
Thank you.
And we've got a question, I think, in the chat. I always I don't know about you, Jane, but I always get terrified when there's a question in the chat, because I think there's going to be one of those awful moments where somebody says something completely undermines everything else. I'm going to reveal.
I'll leave that to you, Stephen. I was just going to say there's a comment from Laura about Milton Keynes putting in direct contact into care plans, and it's routine now. And just to quantify what I said earlier, there are some local authorities that I work with for against that are doing that routinely, but there are some that are still, in my view, on the cases I've dealt with, resistant. And I think so it does depend on the local authority, but I don't want to tar every authority with the same brush. So yes, Laura, I agree, but I think it is something that is slow to catch on in some authorities. I don't know what your experience of that is, Stephen.
Yeah, sorry, I was rather trying to look at Hazel's questions. I wasn't really listening, Jane, so I'll sort of flag. Sorry about that. Hazel's asked a really good point, if I may say. I can't read it all, Hazel, so forgive me. It's not my age. It just doesn't fit onto the screen sufficiently. But Hazel's saying, regarding the case about placement orders and contact, sibling contact, do I find it interesting that Lord Justice Baker made decisions about post-adoption contact in other cases? And I think I absolutely agree with you. I think there is a sort of trend, is there not, towards a greater openness towards contact post adoption, but also to a more careful analysis of what is happening at the placement stage. When I was at the bar all those years ago, you just would not have post adoption contact, and any question of there being contact post of freeing for adoption, as it used to be under the Children Act 1975 order, would be, well, you'd hear the judge saying that's up to the prospective adopters, isn't it? And it would end there, although there were statutory provisions for contact at that stage. I agree, Hazel. I think things are moving on, and the President's speech about this issue was really interesting. And I would be interested to see whether somebody doesn't take this whole area of adoption law further for it to be analysed by the Court of Appeal. And I would have thought it's an issue that one day will find its way to the Supreme Court, and perhaps that would be a good thing. But thank you very much indeed for raising the question. I hope I haven't revealed my how correct I am to suffer from imposter syndrome in my rather flaky answer. Okay. Well, we really hope you've enjoyed this and you found it helpful. Get in touch if we can help further. And thank you very much indeed to LexisNexis for supporting us with this. So back to the barbecue. Okay.
Thank you. Take care.